Okay, thank you and good morning, everyone. I'm Asim Rahman. I'm the Commissioner and Chief Administrative Law Judge here at Oath, also the Chair of the Environmental Board. I'm very pleased to call this meeting to order of the August 3rd ECB. And I just want to take a moment to welcome everyone in person, our board members as well as our guests. It's really nice to have a meeting that's in person after being in the squares for so long. There is indeed a convenience to doing it online, but there's something important to being in person. It helps us, particularly with the important issues that we deal with and the conversations we have to have. Being in person helps us create this sense of community that we need to have those conversations. So once again, thank you for being here, and I look forward to many more future meetings at 100 Church. So I will ask the GC team to do a roll call and to verify quorum.
Good morning, all. We'll start with Commissioner Asim Rahman.
Present.
Amanda Graham.
Present.
Joseph Gregory.
Present.
Elizabeth Nauer.
Present.
Madeline Igori.
Present.
Thank you. Harminda Parana. Russell Pickens.
Present.
Thank you. Matthew Snide.
Present.
Thank you. Thomas Stettner. Matthew Smith.
Here.
Douglas Swan.
Present.
Thank you. Gerald Whittington. Okay, we have a quorum 10 out of 12.
Great, thank you very much. We now ask for a motion. We'll now discuss the minutes of the June 1st meeting. I hope everyone has an opportunity to read them. Does anyone have any corrections to the minutes of the June 1st meeting? I'd like to request a motion to adopt the minutes. Okay, I have a motion from Joseph Gregory, a second from Madeline.
Are there any objections to the motion approving the minute of the June 1st, 2023 ECB meeting? Hearing none, seeing none, the motion is approved unanimously.
Okay, thank you, everyone. I'll now turn it over to the Oath General Counsel, Oath Staff, for a presentation on a resolution concerning the open meeting law procedures. Open.
Hi, good morning, everybody. It's so nice to see everyone in person. We discussed this resolution and we discussed the ins and outs of the amendment to the open meetings law that now for a period of time, for a period of 1 year, it's kind of like an experiment of allowing video conferencing in certain circumstances. And in order to take advantage of that, the board or the commission or the body would have to pass a resolution allowing that. And that's what we've drafted, as we discussed last time. We've drafted a resolution for your consideration, which allows us to take advantage of the opportunity for certain members under certain extraordinary circumstances to participate through video conference. So I've presented it to you, and I'm very happy to answer any questions you might have on it. There are actually 3 parts to it. There's the resolution itself. The resolution calls for a body of procedures. And so I also drafted the body of procedures, and I also included a copy of the law so that you guys could see what this was all about. So I'm happy to answer any questions you might have about it.
Do we know what counts as an extraordinary excuse not to be here?
Okay, so in the legislation, they gave a few examples. They said disability, they said caregiving, they said illness. So, and then they threw in these broad basket terms of like exigent that kind of exigent circumstance sort of thing. So I think we can gather that it has to be more than I really just don't feel like taking the train. You know, it has to be more than that. It has to be a circumstance that you feel really requires that you're not present. And you also, one of the things to keep in mind is that you can't decide to just do this on the same day. I mean, unless it's, you know, you're in traction or something. You have to ask 4 days before the meeting actually let the someone from Oath know that you will not be there, so that we can then do a public notice to the public that you will not be there, that you'll be joining from video conference, because the public has to be apprised of who's there, who's not there.
I'm sorry, so how would that work if you're sick the day before?
So if you're
That's
sick the day
right.
before, what the legislation anticipates that, it says that the board may reschedule the meeting if they don't have time to, to do the public notice. So we're not required to reschedule the meeting, but you may reschedule the meeting. And the reason they're so flexible about that is that the person who is seeking permission to appear by video conference is not necessary for a quorum. That's one of the main things of this law, that the only way it's going to work is if that person who's seeking to appear by video conference is not necessary for the quorum. You have to have the quorum number in a public place for one of the members then to say, I can't show up in person.
Just to make sure I understood correctly, so in other words, we have 9 people present, somebody misses a flight, we have a quorum. The 10th person is irrelevant, is what you're saying.
They can still participate and
Okay.
vote in the meeting, but they're not necessary for the quorum.
I understand. That's exactly my question. Thank you.
Yeah.
That's the clarification.
The alternative also being A, reschedule, or B, if it's less than 4 days, they would just not be counted present. Right? Alternatively, you can proceed with the meeting and they're just not a participating member.
Yeah, or it doesn't really say that necessarily in the
Yeah.
law. So I figure that if we make the due attempts at publicizing it, we might be able to get away with it depending on the circumstance.
Look, I think this is a great way to go, and I thought this was all pretty well written, but it seems like maybe we need like a little bit of FAQ or something, just or training. I don't know, some bullets.
Well, you know, frankly, if we continue to do what we're doing,
Yep.
there's not much more you need to know.
I don't want to boil the ocean. I'm just thinking out loud. These are some good questions. It's just, you know.
Yeah, so these are things also, you have my email.
Yeah.
So you can always just contact me and say, you know,
No, I
I'm
thought,
having this situation, but what do I do here? Do I count? Do I not count? We can handle. But in general, this is in general. In general, we need a quorum, physical quorum.
yeah,
And a person outside of that who still wants to participate and still wants to vote, but can't do it publicly, they still have an opportunity to participate. They don't have to beg off.
I think this is all great. I'm sorry, I'm supposed to introduce myself. Tom Spetner, citizen member. I should have said that. It's an open meeting, right? I was talking about this with Peter, because I was studying the legislation and I didn't quite understand it all until I really read it. And, I think it's a great idea, but I don't think having it all on our website just makes the meetings even more open, you know, more journalists can see us or whomever, right? Somebody who doesn't live here anymore and moved across the country, but cares about some issue. It's pretty good, I think. So it's more open.
Yeah.
Shamanda Graham, Department of Buildings. I have 3 questions. The first one, it talks about posting on the webpage, and we're using the term ECB all throughout here. Is the posting to the webpage, is that on the oath webpage, and does it matter that we're using the term ECB?
Well, no, it doesn't, because ECB in the charter, ECB is part of oath.
Okay,
So, you know, ECB is expected to be on our website, is expected to have its hearings held in the oath hearings division, et cetera. So there's no conflict there.
okay. I mean, I don't have any confusion. I'm just a little bit worried about the public, because when you go to the website, you see oath everywhere. So I just don't want anybody to think they're in the wrong place. And then the other question I have is with regard to number 9, if members CPR authorized to participate, it looks like it's saying that once we participate via video conferencing, that we must then allow the public to do so. So,
Yeah, once there's one person who's on video conference,
Mhm.
the public is allowed to participate also on video conference.
So I'm understanding correctly that if everyone shows up in person, then the public may not participate video.
Yeah, if everyone is in person,
Okay.
no, then we're under no obligation to have it.
Okay,
Well, just to advance the question, then, why not make ourselves just available pro forma on the web?
There's no law stopping us from doing that.
Right, that's my point. Exactly. Why wouldn't we do that? I think it's a great idea.
well, that's what,
In a live sense or posting the recorded meeting?
Well, I know we do the latter, don't we?
Yeah.
But I wouldn't have an issue with the live. You know, I think it's a good idea, but it just would increase accesses in a vacuum. I think it's canny. If we don't do it, we don't do it. It's fine. The recordings come out, but
It's an interesting point, Tom. Let's hold on that for a moment, since that's not tied to this, but it's a relevant topic. And let's continue discussion on the resolution because there have been some good questions. Did you have other questions, Shimon?
No, I'm done.
Any other questions on the resolution? Okay, so before we move to a vote on it, since it's a related topic, does anyone else have general views on this notion of right now we are currently posting the meeting after the meeting online, but doing it as a live broadcast? I'm not sure. Right now it's live?
People can join WebEx. We publish
Right.
the WebEx invite as part of the public notice.
And we have no reason to stop doing that.
No.
Okay.
we have no-
Yeah, there we go. Okay,
Well,
so
right.
I would like to request a motion to adopt the resolution regarding the open meetings law. Okay, we have a motion from Matt and a second. Okay, we have a second from Tom. And a vote, please.
Are there any objections to the motion to adopt a resolution respecting the open meetings law procedures? Hearing none, seeing none, the motion is approved unanimously.
Great, thank you, everyone. All right, we will now continue with with the General Counsel's Office and a presentation on a resolution respecting stormwater hearings.
Hi, once again, hello, everybody. You have another resolution for you. This one, the foundation of this one is pure practicality. As you know, the DEP is charged with issuing cease and desist orders and in many different contexts. And in one particular context, a development/construction context that has to be done very rapidly. And the law actually requires that if DEP issues such an order, ECB is supposed to hear, and if there's a written application challenging the DEP order, ECB, us, we're supposed to gather within 2 days and make a determination. On a practical level, I don't think anyone thinks it's a practicable idea to have a necessary quorum within 2 days in a physical location. So in order to make sure that we submit ourselves or we comply with the law, because the law requires us to do it within 2 days, this resolution is asking your permission for the chair, for Commissioner Rahman, to appoint an oath employee to actually do this hearing within 2 days. And I'm happy to answer any questions you might have about that.
Okay.
Elizabeth?
Good morning, Elizabeth Nauer, appointed member. I guess I was just wondering, do you anticipate that this would be, you would be designating a particular person or persons to handle these cases? So there's sort of some consistency in how they're adjudicated.
That's ultimately going to be up to the commissioner, but I can't imagine that we would necessarily do that because it would probably be a hearing officer.
Would just be sort of in the general pool.
Yeah, exactly. It's the person who's available and Amy's running the hearings division. So it's the person who's available, the person with the skill set, the person, perhaps someone in Peter's shop as well, who's present and skilled.
Okay, so it's kind of like a magistrate when you have a TRO and that
Exactly.
someone just take an emergency application
Yes,
because of
that's-
its unique time sequence.
Exactly.
All right, that's an analogy I needed. That's,
Yeah, but Elizabeth, I'd be interested in hearing more about why you asked that question, because as, if this resolution passed and it falls on me to designate the individuals within oath who are going to do this, it would be helpful to know any concerns are of board members.
I think the concern is that, I understand that there may be an issue that the simplest case is they just haven't gone through the process. And so there's a yes, no decision to be made, but I don't know. I guess the cease and desist orders could also pertain to situations where DEP is alleging that they're not complying with their stormwater pollution prevention plan that's approved by DEP. So that could get really into very technical issues. So this is it is like a highly technical and very complicated area. So I would encourage you to consider at least some training for certain hearing officers, maybe that they could understand this particular area of regulation because it's pretty complex. I could see situations where DEP is making assertions that there's non-compliance and issuing a cease and desist order, but where the developer or the builder or contractor is in a position where they disagree with that on a technical basis and their projects being stopped immediately, and it could be really sort of problematic for them to have to sort of present a technical case to somebody who's not well versed in the area. So
thank you for that perspective. Just to add on what you're saying, because I think you're right, there are elements of the legal standard that talk about whether the situation presents a danger. And whether a situation presents a danger is not a black and white issue. That's something that's going to be very fact specific. So I think it is important to make sure that whoever we determine to be the adjudicators for these matters are aware of the technical issues, are aware of the law around them. We continue to express high confidence in all of our staff attorneys and hearing officers who work on these matters, but because it's new, it's something that we will definitely be attuned to. So I appreciate that comment. Yes, Russ.
Yeah, just to clarify why this came up. Russell Piccioni is with DEP, by the way. We've been enforcing the stormwater rules for about a year. We come across construction sites that require stormwater permits from DEP that don't have them. What we're doing right now is giving them a summons, but because there is no procedure for them to have the hearing that they're required to be given under the law, we can't issue a stop work order. So the only scenario that I think we would anticipate issuing one of these stop work orders for is if a covered construction site does not have a stormwater permit from DEP, and the grounds that I think I could think of on which they could dispute that would be either, yes, we do have one and you're mistaken, which I think we'd know if we gave them a permit, or we don't need one. And the criteria for when you need one can be quite involved. It involves how much soil is being disturbed and impervious surfaces and where the sewers are. And so that could be conceivably a grounds where they could dispute the need for the permit.
right, and I think that that's a good point, Russ, that it can be very complicated. And I think because these regulations are newer, even the consultants and contractors are still sort of learning what the requirements are and when they apply. So I think that also points to the need for whoever is designated to hear the cases, because it would involve stopping work and not just issuing a violation that could be appealed. That, you know, there should be some means of training people in these, especially where it's a very discrete issue. It's going to end up being really the application of the requirements, so that I don't think it would be a high burden to.
Yeah, and I think that this provision, I think, has been in the sewer code since it was enacted in the 1970s. It's never been used before. And so when they wrote this 50 years ago, I don't think they really anticipated the current structure of things, and that giving people a hearing in 2 days was really going to be quite difficult.
Right, and that's very much why, again, to return it to why we have this resolution. The resolution is here so that we have the infrastructure in place to have those hearings. The law is there. The EP is going to do its enforcement. We do not want to have to call all of you in within 2 days of getting a notification to make a decision. And it seems like it's more practical to have that delegated in a way that we can have that decided by the folks who are looking at cases like this and other cases on a regular basis. Other comments?
More of a question, and maybe it's for Russ, but do we have any like business intelligence or forward-looking anticipatory evidence of like how much this is gonna happen? I mean, I know you can't predict the weather and you can't predict like the infrastructure of the city changing, and I give you all the caveats in the world, but is this gonna happen on the daily, or is this gonna be like once a quarter? You know,
So far in the first year, I'd say off the top of my head, we've issued about a dozen summonses for not having a permit, maybe 15.
and that was for 2022?
In about the last year since we started enforcing.
That's good context. All right, so one or two a month sounds normal to you?
Yeah, and then we don't know, of course, how many people, within the cases where we've issued summonses for not having the permit, what everybody, I think, has done, has gone and gotten the permit and received a mitigated penalty on the summons. I don't remember anyone so far disputing that they needed the permit, but it's certainly conceivable that someone could.
And the dispute would be the scenario in which you might issue a stop work order and then that would proceed to the.
Yeah.
Okay, got
I
it.
just, again, the stormwater rules are very technical, very complicated. The manual is like 200 pages long. When we amend it, the city record needs an extra week to be able to publish it. It's really granular stuff that's written for engineers and real estate developers and so.
Good, thank you. Other comments or questions on the resolution? Yes.
Doug Swan, citizen member. Just another question for us. I was just curious as to what was the impetus for DEP to start issuing the summonses? Just out of curiosity.
Yeah, I'm sorry.
What was the impetus for DEP to start issuing these types of summonses?
Just, we got the rules promulgated about a little over a year ago, and then we had to set up an enforcement unit. And so, you mean, what is the impetus for sending an inspector?
I guess-
When will they go to a site?
I'm almost talking about the technical rationale for starting to issue these types of summonses.
I'm not.
And you may not know that.
That's really, I'm not sure. But I mean, I think we do respond to complaints, and I think there are also scheduled inspections for construction sites that cause us to go out.
Other comments or questions? Okay, I'd like to request a motion to adopt the resolution regarding the sewer code and stormwater rules. Okay, I see a motion from Shamanda, a second from Matt. Thank you. Vote.
Are there any objections to the motion to adopt a resolution respecting stormwater hearings? Seeing none, hearing none, the motion is approved unanimously.
Thank you. Okay, we will continue with Russ Pecunis from DEP and move into the discussion of what I believe are two cease and desist orders, and we could take them one by one. Yep, Russ.
Okay, great. Thank you. So this meeting, DEP is requesting that the board issue two cease and desist orders. Both of these are under the noise code. The first location is 79 Reed Street, which also is known as 97 Chambers Street. The fact that there were three summonses and they were issued for two different addresses is why I attached the printout from the DOB website on the last page of the attachment for this one that shows that 79 Reed Street is also 97 Chambers Street. This is a lot less store, and the building is managed by Brownstone Management Corp. The building has an air conditioning unit on the roof. The original inspection was done on June 1st of 2022 and found that there was excessive noise from the air conditioning unit. They were found in violation on that summons in November of last year. The second summons was also issued last summer in August, and they were found in violation on that summons in December. Then there was not another inspection until May of this year. I would imagine because this is an air conditioning unit and they stopped using it for the winter. And they were again found in violation for excessive noise from this unit in May of this year. That hearing on that summons is coming up next week. Since they have been adjudicated in violation with regards to this equipment twice, and the inspection, the most recent inspection in May found that the equipment is still too noisy. DEP is requesting that a cease and desist order be issued, and that because one of the tickets was issued to the tenant and 2 were issued to the managing agent, that the order be issued to both.
Any questions for Russ? Yeah, Ben.
Yeah, hi, Matt Schneider, citizen member, appointed member. Is the solution here that they need to get a new system, or they just need to find whatever solution they have to lower the volume on the air conditioning unit?
In terms of how they would be able to address
Yes.
this. So an item of noisy equipment like this could be addressed in multiple ways. Could be addressed by replacing it. Could be addressed by fixing it if it's noisy because it's broken or needs to be maintained. You can reorient the direction of the unit so that it's away from the residential receptors. You could build a little acoustical structure around it. How they would address it is up to them, as long as they come into compliance with the code.
And do we have any concern that the first one was to the actual tenant and one was to the managing agent, and it's not all to the same party receiving the complaints violations?
I'm not, normally these would have all been issued to the same
Right.
respondent. The inspector chose in the first case to issue it to Lot Less, and in the second case to issue it to the managing agent, and then the one this year was also issued to the managing agent. They would both be considered owners under the noise code because the definition of owner is very expansive. And because it's the same piece of equipment, and because there are continuing complaints about it, like right up to now, normally what we may have done was wait until we issued a third summons to the managing agent and then just presented this with 3 summonses to the same respondent. But because there isn't another meeting for 2 months, and because this is a continuing problem for the people that are complaining about it, we decided to ask for the order, even though it's 2 different respondents, but it is definitely the same equipment.
And so Russ, there was 1 prior summons or 2? I'm sorry.
So there are 2 that have been adjudicated, one against each party.
Right.
And then the new one that was issued in May and has a hearing next week is issued to the managing agent.
Okay, and I'm looking at the second page that both that have been previously been adjudicated have been paid.
Correct.
So we have what appears to be a scenario where the respondent's paying, they're just not
They're
addressing
both
the
aware
underlying
of it.
situation.
Yeah.
Just to kind of think out loud for a moment, I'm in, just to share my point of view, I'm in favor of approving the cease and desist, but I'm just thinking through what does it mean that there's a hearing next week? And is there anything about this that suggests, should it be approval pending the outcome of next week's hearing? But it also appears that, well, if they are found in violation, they may just pay again. That's not going to solve the problem, the next hearing, unless, but if others have different views on that as to should anything about today's cease and desist be somehow related to the fact that the next hearing is only a matter of days away. Elizabeth?
Yes, Elizabeth Nauer, appointed member. I don't think that they should be tied together because, anything could happen at a hearing. There could be a service issue, et cetera. So I would tie the determination of whether to issue the cease and desist to the outcome of the hearing. Also, as you said, they might just pay it or there could be, various outcomes based on the hearing officer. I did have a question as to, I guess they were all paid, but that doesn't necessarily mean none of them were appealed. Were there any appeals filed in any of these?
No, these were both adjudicated last year, so the time would have long since passed for them to appeal either of them.
Okay, Tom?
I had the same point. I think these are swim lanes that they need to be kept administrative. It's a great question, but when you kind of deconstruct, the hearings can be delayed ad infinitum, ad alone, I think is I had the same.
Right.
It's a great question because there's an obvious linkage, but I think they need administrative
Right.
separation.
Yeah, I mean, one of the motivations behind the question is because we're talking about, these are large stores, people use them, and to shut down, to say cease and desist is effectively shutting down a store because the air conditioning won't be present in the store. And I want to make sure that we take that into account. Okay, that was the only other question I had. Yes, sir.
Joseph Gregory, Fire Department. How much are the penalties? Because it sounds like the cost of just paying the penalty outweighs whatever fix they have to do for the air conditioning unit. So it's maybe there's just the cost of doing business.
Believe that the first offense penalty for 227 is either $220 or $440.
Yeah, so it's probably more expensive for them to.
Well, yeah, $30,000 air conditioner. Lot. You gotta, this is you gotta have a scene.
Yeah, I understand. Amanda, did you have something?
I was just going to say, I don't really have concerns about them necessarily shutting down because I do think that the penalty is playing a huge role.
Yeah.
Whenever the penalty is not larger than the cost of doing business, they will just pay it and continue to pay it. And even if they have the hearing next week, we have two previous hearings with findings in violation, and I think that's enough to support.
Right, and Matt raised that good question. If it's two hearings, but it's with different parties, but at least they've each had one shot.
Exactly.
So, okay, any other questions on this one? Good. I'd like to request a motion and a second for the cease and desist regarding 79 Reed Street, 97 Chambers Street. I see a motion from Elizabeth and a second from Tom. Will we do a vote, please?
Yeah. Are there any objections to approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Thank you. Russ, let's move on to respondent Anita Forever.
Yep. All right. So the second request pertains to 195 DeKalb Avenue in Brooklyn. The corporate respondent is Anita Forever LLC. The name of the establishment in question is the Saragina Cafe. I don't know if anyone is familiar.
Yes, Elizabeth is familiar.
Elizabeth is, okay. We have issued 4 summonses at this location for noise from the kitchen exhaust and from a refrigeration unit, both of which are located on the roof. The first summons was issued in June of last year, which they stipulated to and paid in August. The second one in September of last year, they stipulated to and paid in November. Then they were issued a third summons in March of this year, which they stipulated and paid in May. And they were just issued a fourth summons last week. So again, on this one, because of the repeated violations and the continuing failure of the respondent to bring the equipment into compliance, DEP is asking that the board issue a cease and desist order.
Thank you, Russ. Any questions? Concerns? Okay, I'd ask for a motion to issue the cease to approve the request for a cease and desist order regarding 195 DeKalb Avenue. Madeline, thank you. A second. Shamanda, okay. Do a vote, please.
Are there any objections to approving the cease and desist order? Hearing none, seeing none, the motion is approved unanimously.
Great. Thank you,
All
everyone.
right, thank you.
I just want to take a moment to note that in our meeting, at our last meeting, as reflected in the minutes when we were looking at some cease and desist orders, we requested that the DEP update its, the affirmation documents to make clear that the issue is a continuing issue through the date of the signature. I've seen in the last two that you've added that, so thank you, Russ, for your team for doing that. It's helpful for our evaluation to see that these are ongoing violations. So once again, thanks to your team for making that change so promptly. Okay, moving on, we are now ready to go into executive session. Can I have a motion to move into executive session? Tom, a second. Matt, thank you. Vote.
Are there any objections to the boards going into executive session at this time? Seeing none, hearing none, now we can enter executive session.
Okay, so we have some logistical changes we need to make. Peter, if you could help us get into executive session. Yeah, thank you.
I have to stop recording.
Oh, yes, Amber, if you want to pause the recording.
Or give me 1 second, please.
Thank you.
And Lisa Urban needs to be moved to the lobby. Thank you.
So did we just throw out all of our interns or something?
Thank you.
Okay, were they still in the waiting room or left?
No one's in the waiting room.
Thank you, Amber. Okay, we are returning to public session and just giving a moment for some of our in-person guests to get seated.
To do a full presentation.
Okay. Okay, thank you, everyone. We're resuming our public session. We have a case before the board. It's Dietmar Dietering v. Jackson Hole, appeal number 2300403. And we are going to, I'm going to ask for a motion to take a vote on this case. I see a motion from Tom. I see a second from Madeline. And the question on the table is, are we voting to affirm the hearing officer, and that is dismiss the summons? And should we take a roll? Okay.
Let me call board members' name and then please let me know whether you are affirming hearing officer's determination. Commissioner Asim-Lehman,
Yes, affirming.
Jamanda Graham,
Affirming.
Joseph Gregory,
Affirming.
Elizabeth Nauer,
Affirming.
Madeline Igori,
Affirming.
Matthew Snyder,
Affirming.
Russell Pickenis,
Abstain.
Thomas Spender,
Affirming.
Matthew Smith, affirm. Douglas Swan,
Affirming.
Thank you very much. It looks like our numbers have us past the required numbers to carry. Am I correct?
Yeah.
Okay, good. Thank you very much. And just for the record, part of the discussion that the board had involved making some adjustments to the drafts that we've reviewed. We are requesting that the Oath Appeals Division adjust the draft that affirms the hearing officer and dismisses the summons to add further discussion regarding the fact that in this particular case, the noise was in a private space that was owned by the restaurant and that had its own seating area, outdoor seating area for its restaurant patrons, as well as a decision including a longer discussion regarding the inference of whether or not this is commercial or business advertising noise. Okay. Moving on, let me just, I believe we've reached the end of our agenda, but for picking our next date, does any board member have any off-agenda items or additional matters that they'd like to raise? Okay, let's discuss our next board meeting date. Possible dates that we have put out are October 5th and October 12th. Does anyone have any scheduling comments on October 5th or October 12th?
October 12th, my preference, have a meeting on October 5th, I think.
Anyone else have any particular objection to October 12th? Okay, I'm not hearing any objections, so let's have the next meeting, which will be in person here at 100 Church Street on October 12th. All right, move to adjourn the meeting. Anyone? Madeline, second. Matthew? All right, and we are adjourned. Thank you very much, everyone. Appreciate your time today.
Thank you.
And the record.
Meeting again before that.